I'll be your host. I'm a proud FSB member and also an MC and BBC broadcaster. But today is not about me. My job is just to guide the discussion because I am joined by some industry experts who are going to share their top tips and advice and help us as we go along. And they are DS Peter Gartland, Police Intellectual Property Crime Unit, Dr. Ruth Brown-Shepherd from the SYJTL, and she's the scientific business consultant there. Miles Rees, he's head of enforcement campaigns at the Intellectual Property Office, the IPO. And Neil Sharpley, Neil chairs the FSB Home Office and Ministry of Justice policy units. Now, these guys are all very well read, and we'll be going through a number of topics. You can ask questions. We've already had some submitted. You can do that through the Q&A. We'll keep an eye on that. And just to remind you that if we don't get to your question, everybody who's on today's session will receive an email later on. And there'll be links not only to this recording, which is available on Catch Up, but any top tips that we share or websites or places that you can go for further resources will be shared in that email. Now, we all know that protecting your products and brand is important. Quite often we overlook it, but if things go wrong, it can really damage your reputation, your finances, and of course, it's an incredible worry for people if those things do get compromised. But before we dive in and tackle those important issues, let's take a look at this important message from Mark Pawsey, MP, MP for Rugby.
Protecting your brand, your intellectual property, and your products from imposters is a key to any business's success. It's great to see this event from the FSB and Amazon aimed at helping small businesses take the steps to keep themselves safe and to find out what to do if the worst should happen. I do hope you'll enjoy this session.
Thank you to Mark there. Now, as I mentioned, this is the second of 3 sessions. We have another one coming up on the 27th of November. That one's all about finance and fundraising. But today we are talking about products and brand and protecting your business in that way. And I'm going to dive straight in and come to you, Miles. Miles, welcome. It's an important issue. What can people do and why should they protect their products and their brand?
Thanks, Dave. Thanks. And thanks also to the FSB and Amazon for inviting me here today. I think it really starts with what you actually own. So a business needs to really think about the different rights and the different things that they might own. And they might not have ever thought of them as intellectual property. So I'm thinking about maybe a brand, which would be your name. Do you own your website? Do you have an innovation or an invention? Perhaps you have photographs or film or video. All of this is intellectual property and it can all be protected by various different means. Now, you don't need to come to the IPO. It's not absolutely essential that you register your patents, your trademarks and designs with us, but it can be very helpful. Also, copyright is automatic. So that's a great right in that as soon as you create something, it's automatic. But people just need to be aware, yes, you probably own quite a lot of things, but you can't register everything. There are rules and regulations around this. So it requires a little bit of thought and a little bit of preparation before you take forward that type of protecting formally, should we say. Let me give you an example, a very easy example. The very well-known battery brand, Eveready. Now that tells you in your mind that this is a battery that's always ready to help you. But if it said long-lasting, we wouldn't let that be registered because that just describes it too bluntly. But Eveready has a subtlety, has a cleverness about it, and that's been registered and for many, many years as a trademark.
Some people might be put off, I guess, small business owners looking at finances, particularly at the moment, and think, oh, I can't go through that process. It's going to cost me too much money. And I'm not really sure about which aspects of my business. Do I just protect my name? Or like you mentioned, all the other things, website photos, are there some shortcuts? Is it an expensive path to get this done?
In terms of the very basic fees, you can get a trademark for under £200 that will last you for 10 years. However, I would really suggest that people don't just dive in. Take a step back and think strategically about what the brand actually means, what you potentially want to protect it for, because you pay different fees for different goods and services. So it isn't a sort of, it is quite a complex process, but you know, it's been simplified. And a lot of people do it, file applications themselves for trademarks and designs. Patents is slightly different. Patents, really, I would strongly recommend people get professional advice for patents. There are a lot of organizations that provide advice for nothing. I know the FSB has guidance and information. And in fact, even Amazon on their website has information for rights holders, whether they're registered or not, in terms of protecting their rights on the Amazon platform. So a lot of advice out there, but it requires a sort of strategic, thoughtful approach before you dive in and you know, file an application to us just on the internet.
We'll come on to other reasons why you definitely should look into this and pursue it, particularly if your brand is compromised, or if further down the line someone says, actually, I've got that name or that brand and you can't have it, and you've got to change everything, including your domain. We'll come back to that. But Ruth, welcome. Ruth, you're already on this journey. Just explain a little bit about what you're protecting and how you're going about it.
Thank you. Good morning, everyone. The brand represents the core values of our business, and it shows that our commitment to a high level of customer service. So it was important to protect our brand to actually maintain our reputation in the science and technologies industry. So as a scientific consultancy working on a national basis, the most big value for us was actually the business name. So I decided to register the trademark in the UK.
And a reasonably easy process. You followed it easily enough, did you?
Actually, instead of doing it myself, I decided to hire a technical professional to do it, who was a specialist in trademarks. There were 3 key stages. Basically, we chose the classes, which actually is where your business operates. So for me, class 41, for example, covered my training services. Then also agreed to do the optional searches, because the searches allow you to check that no one else has a similar trademark, and then register the trademark to cover both the services we're doing both now and in the future, because we have to think about what we might be doing in the later stage as well. The whole process only took 9 months, so it was actually quite good.
Going back a few years, and it may have changed, when I registered a trademark for a publishing company, I think it was published in one of the national newspapers for several weeks, so that people could contest it. I don't know, have you had to go through something similar?
That was all done by my trademark attorney on my behalf, and no one came back, which was great, because it's a unique trademark, thank goodness. But that also helps with the searches that you do in advance. So if you do the searches, it actually takes away a lot of the trouble that you'd worry about at that point as well.
And Miles, just coming back to you, of course, when you go through these steps, you have some civil rights that you're protected, aren't you? That's the law.
Yeah, absolutely. So even if you register or don't register, there are specific ways you can protect rights in the UK. So they're split into 2 distinct sections. There's civil protection, so through the civil courts, and we're very lucky in the UK. We've got a dedicated court, the IP Enterprise Court, which is specifically there to protect businesses in the UK. So, for example, I often asked to sort of give an example of the sorts of things that court protects. It would protect all sorts of intellectual property. So, even in its most simple terms, if you own a brand, I don't know, you own a local hairdressers, and your business is called Cool Cuts with a Z, and someone opens a business down the road with Cool Cuts, with an S. So a very, very similar name, but you've been trading for some years, and the new interloper that starts isn't the best hairdresser and starts snipping people and, taking bits of their ears off, for example. So you think, well, I'm not putting up with this. They're damaging my reputation. You can take them to the IP Enterprise Court, and you can take action against them and stop them from damaging your reputation, whether you're registered or not. Registration assists you without question. I would recommend businesses strongly consider registration, but there are protections beyond that. So that's the civil, and then you've got the criminal protection. So if you're a successful brand, and I hope people who joined us build brands and become incredibly successful, you run the risk then of counterfeiting. So the big brands are the ones that are the Ralph Lauren's, the Adidas, the Puma. Counterfeiting goods are the more popular things, and that's sold at local markets or maybe online. And that's something that obviously Peter from the Police IP Crime Unit knows all about and frankly deals with in the UK. And we're very fortunate to have a dedicated police unit that helps protect the big brands.
You provided me there, Miles, with a superb link to Peter. Peter, welcome. You're with the police unit. Things can go wrong and then you guys get involved, presumably.
Yeah, good morning, Dave. Good morning, everyone. Thanks for having me along today. Yeah, you're absolutely right. We will deal with trademark infringements, counterfeiting of goods, and any intellectual property related crime as far as we can under UK jurisdiction. And indeed, if we can internationally reach out to do that, we will do that as well, working with partners. We are very lucky here in the UK that we have a dedicated intellectual property crime team. We will work and we will consider any case that comes to us. So certainly for smaller businesses, perhaps while you're beginning to get your businesses off the ground, if you have an issue, it's really important that you come to us and talk to us. You've obviously got the IPO that you can go to as well. But we will certainly try and deal with any intellectual property offences that we can on your behalf. It doesn't matter if you're a one-person business or you have 300 employees. If there's an intellectual property infringement, we can assist you there, then we will look to do that.
I suppose it's an interesting line that has to be crossed for it to become a police investigation, other than perhaps a civil or a lawful investigation that you might take through the courts. What is that distinction?
I think the sensible way to try and deal with intellectual property infringement is to try and go down the civil route. That is a lot more straightforward. You can ask a process server or a solicitor to send a cease and desist letter, perhaps for the lower level elements of intellectual property infringement. That's not to say that the criminal process is not suited for smaller cases. The offence is the offence, and the scale of that is almost immaterial, really. If the legislation is contravened, then we could look to deal with it. I think generally speaking, if we can try and focus criminal proceedings on the larger cases, the courts are more entertaining of that. The court spaces is obviously very limited, and timings for getting trials and criminal cases off the ground is lengthy. But there are other remedies that we can deal with. Essentially, if there is something that is of concern to you around intellectual property, come to us. If it's not a criminal matter for us to take forward, we'll certainly be able to give you guidance or point you in the direction of somebody that will be able to help you.
And that neatly bats back to you, Miles. In terms of pursuing a case, I'll give you a couple of examples. This happened to us in my publishing company, which I don't deal with now, but we registered the trademark. We just happened to do a Google search and saw that someone was going to use the same name, and they were based down in southern Spain. And we just sent them an email, said, by the way, you need to be aware that we've registered that name. And it would have been quite recently, it'd only just gone through. And we just had a polite email back saying, ever so sorry, we didn't realise, and they dropped the name. Now, similarly, only yesterday online, I saw a case where someone had the same thing happen. Someone reached out and said, listen, I've been using that name for 12 years, but when people do a Google search, they come to you and it's getting confusing. Would you be prepared to change your name? And they don't know what to do. They want to keep their name. They're trying to work with this guy, and he's saying, oh, it's damaging me, I'm losing money. And I don't know whether that's going to have to go to some sort of arbitration or whether this guy has got a case at all, Miles.
Well, it can be complicated because IP rights are territorial. So that in the first example you gave about Spain, if you own a registered right in the UK, you have a registered trademark in the UK, that has no bearing on another business operating in Spain using an identical mark on identical goods and services. You would need to file a European trademark to get protection throughout the European Union. Now, obviously, we are no longer part of that. So if you want the UK and Europe, you have to file in Europe in the trademark office in Alicante, and you would file in our office electronically, but we're based in Newport in South Wales. So IP rights are territorial. There are very few companies that have, people say, a worldwide trademark. You're talking the Coca-Colas, the Disneys. There are very few companies that do that. This is about being tactical and strategical. If the infringement is taking place in the UK. So if you're talking about 2 UK companies, potentially yes, follow Peter's advice and potentially go to an IP attorney and get some advice or some free advice through various networks. And I'm going to share some links at the end of the session that can be picked up by people. And then, you know, get a cease and desist letter very often will work. If you feel that you've got reputation and the other side has as well, potentially you can end up in the civil courts, and the IP enterprise court is for the more expensive claims up to $500,000, but there's a small claims track that deals with the sort of lower level claims. If someone has a registered mark and you're trading using that same name, even if you've been trading for some time, you are going to run into difficulties without question. You need to get professional advice. Certainly don't just hide and pretend it isn't going to happen, because eventually as your business gets bigger and your brand becomes more valuable, you know, you really are vulnerable to them taking action against you. So it requires conversations to get some professional advice.
Neil, you've been sitting patiently looking on. Now, Neil, if a small business is just starting up and there's all the excitement of starting up, what steps and what things should they be thinking about? Because most people will be thinking about getting their first sale or doing the thing that they love or making money, won't they? Will they have thought about the steps, and what advice would you give?
Well, can I firstly just pick up on a couple of things that Peter and Miles have said, which I think are pretty important to set the scene. Firstly, trademarks, brand names are a first past the post registration. So it's important that you think about that when you start up. In terms of not registering, and what Miles said is absolutely right. If you've had a business that's been established for a period of time, then you will acquire some goodwill in that business, and then you're able to protect that goodwill by stopping other people interfering with it if they're competing in a way that would confuse the public. But there have been cases where businesses have started up where they haven't acquired the necessary amount of goodwill, or it's limited to a particular area, where other businesses have come in and registered a trademark and they have beaten down the person who was there first simply because they didn't register. And the other point that Miles makes, which is really important, is that trademarks are territorial. And what that means is that if you register a UK trademark, it is only enforceable in the UK. You have to register in other countries. And there is a fairly straightforward European process. There are processes in lots of other countries. And there's an organization called the World Intellectual Property Organization, which enables you to designate other countries and extend your UK trademark into them, following a fairly straightforward procedure. But coming back to your question, Dave, if I may, the key to every startup is preparation and research. So the first thing you should do before you start up, if you're going to market your business at all, everyone has a business name. So everyone has intellectual property in that business name. You've probably also got it in your know-how and the way in which you operate and the confidential information associated with your business. But the first thing you must do if you're going to choose a business name is research. That means get on Google. That means go to the World Intellectual Property Office Browns list and check. You may be operating only in the UK, or if you're going to operate internationally, you need to check what brands are registered in other places. Now, it's not just a question of looking at the names. You've also got to look at other people who, for instance, registered companies with Companies House using those names because they'll be entitled to use the company name. You've got to look at domain names and people who are already registered throughout the world with different domains. Bear in mind there are different domains for different countries, so you have to check that there are people haven't got your name in those particular territories. And you must really be quite comprehensive about this, because you can spend 6 months, say, preparing your business, and if someone gets past the post by registering 2 days before you open and you haven't registered, they're going to have the trademark and you're going to be stuck. And so it's really important that you think carefully about whether to spend that £200 or thereabouts fairly early on, secure the domain names, and look at those things fairly carefully. So the timing's important. The other thing to mention, of course, is that if, as most people are doing, you're trading online, you're going to have to be engaged with online platforms, possibly, as well as websites. The website names, the domains I've mentioned, but the online platforms operate sometimes in a way that you wouldn't expect. I mean, for instance, some platforms are difficult over trademarks. and they register a brand owner within their platform system. And you have to be careful that they understand that the brand owner relates to a particular territory, so that you can make sure that if you're only operating in the UK, you can protect your brand in that platform in the territory. So it's worth having a look at the platform situation as well. I think probably, Dave, that's enough for me to be going on with, but the key is the research and preparation before you start.
Sure, and we'll come back because we talked a lot about brand, but there are other things that Miles mentioned earlier on, you know, photography, you know, other bits. But let's just come back to you, Peter. Everything that has been shared so far, are you seeing infringements on that have become criminal cases?
Yeah, absolutely. We need, and I would strongly advise that all businesses really consider their intellectual property and do get it registered. We do get infringement, obviously, of particular trademarks or indeed products. And if they've been registered, then we can provide greater safety to those businesses that produce the genuine product or own the trademark or have that intellectual property right. A lot of our cases sit with those infringements. And if a business unfortunately hasn't registered that, then they're on a bit of a hiding to nothing, really. It's absolutely crucial. Get it registered. Don't overlook it in the early stages of setting your business up and getting it off the ground. Once you've got that, that really does protect who you are as a business. And then when and if your intellectual property is infringed and you have to come to us, then we're in a much stronger position to deal with that.
And that is the key, isn't it? That you know, we're talking at the moment, the scare stories about not being protected, but once you are protected, you can then take up the case and say, well, this is straightforward. They've registered, the other person or the other company is the infringer, and yes, presumably you have the powers, and the courts have the powers to take those names down, presumably, and impose fines. Would that be the way it would go?
Yeah, so fines is certainly one option as a result of a criminal prosecution and conviction. But you mentioned sort of taking things down. We can take websites down if they infringe. We have a very good relationship with online platforms and with server rooms and website hosts and domains. So we are able to take that down if there is a proper trademark held by a legitimate business and that's been copied or stolen. So yeah, it is really, really crucial. As long as that is trademarked by you as a business, we can help. We are able to take prosecutions forward, and we are able to ensure that your business is protected. And you do run a significant risk of not having that protection if you don't get yourself registered with the IPO.
So let's go back to you, Ruth, because you've already said that are you all the way down this road now, Ruth? Have you completed the process, or is it ongoing? How's things progressing?
I've completed the process, but once you've got a trademark, you can't just leave it. You have to keep using it in order for it to remain protected. So we use it on all of our marketing materials and everywhere that we sort of present the brand. I also actually use the TM registration mark rather than the R mark, simply for the reasons that we've been discussing today, in that if it's sort of seen by someone in another international country, I'm not infringing on anybody else's because mine's only registered in the UK. The other thing I do is put the copyright symbol on any of our written content to remind people that we're protecting that. And as an FSB member, I also have access to the templates on the FSB Legal Hub. So that means that then I can actually put in non-disclosure agreements with any external suppliers and collaborators that we work with to protect any confidential information.
That's a great plug for FSB. I mentioned at the beginning, I'm a proud FSB member, and those resources are available. And of course, Amazon, who are working with us in partnership, also have resources available. I mean, that's the important thing, is that you get as much support and help. I mean, it's never as straightforward as we like to think, is it, setting up and running a business? And this is just one more layer. We talked about cybercrime and scams last week. Next week, we'll be talking about finance and funding. But Ruth, it is important, isn't it? I presume you sleep a little bit better at night now, knowing that you're protected.
Absolutely.
Brilliant. Okay, well, we've had a question already. I'm going to read this one out. Is it illegal for competitors to take content from another website, e.g. text and images and or the design, when setting up their own business online? And that's sort of plagiarism, it's copyright. Peter, let's come to the hard end, you know, in terms of enforcement, and then I'll come to you, Neil, about the softer end, maybe about what you can do. But I mean, if that's happening and you see that, and you think, hang on a minute, that's word for word taken from my site, or that's my picture. Where do we go with that?
Well, come to us initially, bring it to our attention. As a small business operating, you know your business model, you'll know your competitors, you'll know if somebody is stealing your content. Come to us with that and we will look at it. Yes, it is an offence to steal people's content, certainly if logos and designs and things like that are being taken and wholly copied. There's further offences if then goods are being produced and sold under that counterfeit fake banner, if you will. Bring it to our attention, we can look at that and then we can take that forward. Certainly with things like content that's been stolen from a genuine business's website and is using for illicit purposes, we can take the website down. I've already mentioned that we have a very good relationship with web hosting platforms, and we have a dedicated disruptions team under our banners of Opashiko and Op Creative, which are able to take those down in-house, and we do that very quickly.
I'm going to come to Miles afterwards, but Neil, very quickly then, you know, I mean, obviously we don't really want to have to go to the police, but if we're coming to look online, I mean, you could literally put into one of the search engines some of your own copy and see whether anyone else is using it. I don't know about images, there must be other tools you can use, but I imagine when you see that, that's pretty scary to think, oh my word, that's my photo, or that's my wording, or my course. Let's say you're a trainer. What can people, you know, do to protect themselves before it gets to the police level?
Well, can I just mention, first of all, there are three separate things that the question provokes. The simple one is photographs. Assuming that you own the photograph, if someone else has used your photograph, that will be a clear infringement and you can take action about it. If you've created text on your website, then it's a question of to what extent has the text been copied. If it's only a very small slice of it, there might be difficulty. If it's just taken wholesale and put on someone else's website, then you may have copyright infringement in terms of that particular authorship. Then the third thing is possibly the get-up of the website. It's quite possible for people to simply clone other people's get-ups, and there may be a design element in that, a graphic element in that, that's also got some sort of copyright attached to it. In terms of what to do, Miles has already mentioned what we normally call the IPEC, that's the Intellectual Property Enterprise Court, which is a county court technically, but it's part of the Chancery Division in London. It has a small claims track, but at present has a limit of £10,000 in value. What you would do is very simple. You would send a cease and desist letter. We probably all had the Getty Images letters demanding £3,000 or £4,000 for use of a photograph. You'd send them a similar sort of letter, and you would demand that they stop using your material, whatever it is, and you might even demand some compensation, like Getty do, for the infringement. If they ignore you, then you could raise a small claim in the small claims track of the IPEC. They do have sittings outside London, but the court is based in the Chancery Division in London. But it's not a complicated process. The judges there are specialists in intellectual property. They'll understand the issues. As I say, it may be possible to have regional hearings or even online hearings. So there is a process, but you start off with the cease and desist letter and you take it from there. The only other thing I would mention is that you need to be clear that the rights that you are writing about belong to you, because we have unjustified IP threats laws in this country. It doesn't apply to copyright, but if it was applying to trademarks or designs or patents and you sent a cease and desist letter, you might end up being sued for falsely accusing someone of infringement if you're wrong. I think that's all for the moment, Dave.
Yeah, thanks. That leads us to an interesting point. Let's think about content, Miles, then. Let's imagine that, I don't know, perhaps I've employed someone as my trainer, and they go into companies and train people, and then realize that the content that I'm providing with, they could then go and use and set up on them on their own and maybe use, or maybe someone comes on one of my courses and then I hear through the grapevine that they're using the material that I've been providing. A, how do I prove it? And B, what can you do?
I mean, your starting point with that is that would be copyright infringement. Taking images, graphics, text would be copyright infringement. But I would take a little step back and say, was the person that you employed an employee or were they contractors? So did you bring in a firm of contractors to deliver your training? Because if you did, the contractors will own the rights in it and you probably won't. You may have put contractual terms in. So whenever the IPO commissions video, we always say we want to own the rights in it. We put a clause in the contract that says we will own the IP. If you don't do that, the contractor owns. So lots of people don't own their own website. They didn't create it. They paid someone to do it, and therefore, they own some elements of it. Obviously, their brands and things, but the actual work on the website wasn't theirs. Now, let's say they were an employee. Absolutely, you would own copyright in that, and that's what's important about keeping records. Being able to prove, because copyright infringement is automatic. So in other words, as soon as you create, I know someone's asked a question about this, as soon as you create, you own it. So, if I write a book, I'm working on a book in an evening about how to service washing machines, and I get that published, I would own the rights in that. Now, as an employee, if I wrote a book about intellectual property, and I did years ago, don't buy it because it's not worth reading. But the Crown own the rights in that, because that's what I do for a living, intellectual property. So there are rules around employees and ownership. But you need to show the date that you created the work and when you did it. Now, currently, there's lots of electronic ways of proving this. Back in the day, they used to say to songwriters, when you wrote the lyrics for your song, you would post it back to yourself, seal the envelope, don't open it when it came, and you had then some proof that you created it on the said day. There are lots of electronic methods of doing that. But that's one of the core challenges around copyright, is proving when you did it and who did it and who owns it. Because independent creation, so in other words, if someone independently produces a very similar photograph, if you're standing in London, you take a photograph of the Houses of Parliament and Big Ben, if someone's literally standing alongside you, that photograph might be nearly identical that they've taken. You each independently own that. Independent creation stands aside from each other. So copyright can be quite technical, but that's what you'd be relying on for training materials.
Yeah, no, I think with photography, I often talk to photographers and I say, are these mine? That no, it stays with the photographer, and is it deleted off their hard drive? Whether they store those images, which
Absolutely.
are of me.
A lot of people, when you get married, you have your wedding photos done. You purchase the rights to a set of photos, but you don't own the copyright. So if your house burns down and you need another set of photos because you really want to see them again, you've got to acquire them from the photographer. They own the rights in those. Now, a lot of businesses and individuals will ask to own copyright, will request that. But obviously, it's a valuable asset for the creator. You can understand photographers don't give that away lightly. So, you can see two sides to copyright and understanding different rights.
We're getting quite a lot of questions. You've already alluded to that, Miles. So I'm going to say to the panelists, keep an eye on those, and pick up the ones. We cover a lot of it off, but it's a hot topic. Miles, one more quick thing. For my sins, I used to be a part-time fitness instructor, specifically teaching exercise to music. PPL is another issue in the UK, isn't it? If you've got a shop, or you like me, I have to use either license-free music or pay PPL fees to use recorded music. And it's the same if you play music over a video you've created, isn't it?
Absolutely.
Stand yourself in a bit of a risk area.
If you want to play music in your business in the background, you'll often garages playing a radio in the background, or getting your hair cut and there'll be the radio on or music playing. You require the correct broadcast, the licenses to be able to do that. The principles are the same. It's not just in music, it works the same with film, and there are all sorts of rules around doing public broadcasts and allowing people access to things like that. But yeah, absolutely, get your correct licenses in place. Similarly for software, if you've got a business and you're allowing lots of staff to use software, you need to get the legitimate and correct licenses to do that, because there's copyright in those and there's protection, and you don't want to fall foul of certainly not the enforcement of the PPL and others who enforce those rights.
Let's come back to you, Peter. In terms of international, I mean, it was very interesting what Miles revealed earlier when we approached the person in Spain and said, we've got the name, and they could have just carried on and said, well, we're in Spain. It was another English company. It was using an English name, but they were in Spain. We were in the UK, but they very kindly declined anyway. In terms of international cooperation through the EU and worldwide, if I was on holiday and I suddenly saw my product being sold on the beach and it's counterfeit, or I mean, short of going over and say, excuse me, mate, what are you doing? What are you doing to help?
So we work very closely with our international law enforcement partners, with the EU IPO for infringements within the European Union, and with Interpol. It can be a little bit hit and miss. Some countries are much better engaging with us than others, as you would expect when you're working internationally. But as PIPCU, we've got a great network of agencies and other teams and other IP professionals, either within law enforcement or perhaps in the private sector, if you like, internationally, that we can work with. So we have a lot of success with international cases. We've had some great and fantastic court results over the last couple of weeks with convictions where there has been quite large and significant international elements to that. We've been able to obtain that evidence and get that into a manner that has been suitable for the UK court. So you're right, you wouldn't perhaps, if you were sitting on the beach, just go over and talk to somebody, but what you would be able to do is come to us and say, you know, I was in Spain and I saw that my product was being sold at this shop on this street. It clearly is in violation. What can you do about it? We would look at that and go out to our Spanish partners and say, we've got a problem here, and they would perhaps by proxy go and deal with that for us. So it's just about communicating with us, bringing it to our attention, and where we can, even if it is internationally, we will look to try and help you. It's really important to protect British business.
Neil has politely put his hand up, but I know, Neil, that there are lots of questions coming in. You've been scanning the questions and eager to make sure that we cover off some of those. Neil, what are you specifically looking at in the Q&A there?
Well, there are two or three things, and I think it's worth just reinforcing what Miles said a moment ago. There are certain rights like copyright, unregistered designs that are automatic, that you own if you're the creator, you're the first owner. There are others like registered designs, patents and trademarks that you only get the right when you register them. So it's important to understand that distinction. Miles has touched on how you might prove what you have created is yours and when you created it. So I'm not going to say anything more on that. But in terms of the questions that have been raised, logos would normally be artistic works, they would be graphical, they would have copyright. The words literary, they would have copyright. Any designs of products, unregistered designs, would also have the unregistered design right if they meet the criteria. So it's a question of looking carefully at what you're talking about. In terms of dealing with enforcement, if you own those rights, if that's clear, then you can take the actions I mentioned a moment ago in relation to sending a cease and desist letter, taking action via the small claims track, or even possibly using one of the IPO processes that Miles, I think, hasn't mentioned. There is an opinions system within the IPO. There's a mediation system within the IPO. It's well worth looking at the IPO website and seeing what enormous amounts of material they've got there that help you in terms of guidance, templates and so on, go through the various intellectual property processes. So there is a lot of help out there, and we can come to the FSB's help in a moment.
Gosh, there's so much we could cover off, and there are lots of questions. So guys, keep your eyes on those. Ruth, let me just come back to you though for a second. Although you used an agency or an outside body to follow this process, did they come back to you and give you any sort of flags and say, you know, you might want to think about changing your name, or there's stuff going on that, you know, you don't want to go there? Or was it fairly straightforward? Were there any aspects that you had to adjust?
So that comes out when you're doing the searches at the beginning. So when I decided what the name was that I wanted and I designed my own logo, we were looking to see if there were anything similar in terms of the words, if there was anything similar in terms of the industry it was in, did it overlap in terms of even colours, you know, everything. That they check the whole sort of set of things that you wouldn't even think about. And also one of the interesting things that I hadn't considered that they brought up was the fact of how I wanted to sort of protect the word mark, and simple things like black and white versus the colour. So now I can use mine in any colour, in any font, whereas if I hadn't done that, someone could have literally just used a different font and then taken my entire brand. And I was thinking, wow, that's quite scary. So having someone professional to help me with that made a big difference.
Sure, and Neil comes piling back in. This is good stuff, guys, because there's a lot of interest. Neil, what would you say in response?
Well, it's not in response, it's just relating to another question. The key thing is always, and this applies to sounds, it applies to artistic stuff, it applies to words, who created it. You don't get any rights in sound until someone creates a recording of that sound. So the question that someone's raised in relation to sound, you have to ask who created that recording, who owns the sound recording copyright, which is of course a separate sort of copyright. And so you've got to look at that. The other thing that I think I ought to have said is in relation to commissioning, and we've touched on this. If you are, as a business starting up, going to commission someone to design you a logo, or commission someone to take you photographs, or commission someone to write you some blurb to go on your website, have a short commissioning agreement that says that they will assign the copyright in whatever they've created to you, absolutely, so that you own it and control it. The law relating to inferring that you end up with that is a little bit messy. It's far better to have a very simple agreement saying that in consideration for what you're going to pay them, they will assign the copyright to you.
Cool. Miles, I'm going to be a little bit selfish here. I've just thought of something that might affect me, but it might affect others as well. I'm going to use this as a broad example, and it's about knowing where the responsibility lies. So, for example, I perhaps contact a company who are going to be doing the audio visual for an event that I'm hosting as an MC. I decide I want to walk on to a popular song that's been recorded and played in the UK by a top artist. I said I'd like to walk onto that, onto stage. Who takes responsibility? Is it me, the AV company, or is it the venue where that event is being held?
I mean, in most cases, you look for the venue to have the rights to that. It may be specific that the organisers have purchased rights to a specific piece to be able to use, but in most cases, you look to the venue to have that. So long as someone's got it, you're protected. I mean, I think it's not something that people. It's usually organisers and venues that would take that responsibility. I'll let Neil, I don't know if Neil wants to come back. I'm going to answer a couple of quick questions, if I may, very quickly. So someone said, if you've got the same name, but you're operating in different classes, how does that work? Well, they've referred to drinks, so I would guess beverages, alcoholic, non-alcoholic, and then you've got cleaning products. Now, you can have two products with the same name. So, for example, you'll be familiar with Lotus cars. For those of us that are slightly older, we remember Lotus shoes, and Lotus business software used to be very well known. So you've got three, and lots of businesses do use overlapping names, and it is possible to register if someone is already in a completely different field. But bear in mind that you're protected for not just the identical goods and services, but what's confusingly similar. So there's a bit wider than the very specifics. However, be very cautious if the earlier registration is from one of the multinationals where their brands transcend all goods. I often refer to this as the Rolls-Royce principle. If Rolls-Royce applied to almost anything is going to be an infringement, because you can't just lift something that has that sort of cachet and global reputation, and that applies to lots of different brands. There are lots of brands that have tremendous goodwill and value in them, even if they're not registered in those particular categories. So obviously Rolls-Royce is jet engines and motor vehicles, but you know, if you called your new cleaning product Rolls-Royce, you are going to run into a problem. I can guarantee it, and I will strongly recommend you don't do that. But if you are, there's a similar name, because let's face it, there's only so many words. If there's a similar name operating in a different category of goods or services, there is the potential to be able to use it. but I would recommend, exactly as Ruth has said, get some advice. You know, you're entering into slightly more risky territory as you get closer and closer to other brands. So take that step back and get some advice. And finally, yes, you can register sounds as trademarks. It is possible. I was the examiner that accepted a number of sound marks, which for the jingles from ice cream vans that Nestle own. It is possible, but it has to be distinctive, and all trademarks have to be distinctive. So as Neil said, there are issues around who owns the music and the various things like that. But if you remember the Direct Line advertisement where the telephone came flying over and it used to make a dee, that was a registered trademark of Direct Line Insurance. They owned the rights to the piece of music. Even the pips on the speaking clock are registered and owned by an organization. So wow. It is possible, but quite complex. And don't run before you can walk, small steps. But if you do have music that's absolutely linked to your business, get some advice.
Who knew? Peter, we've had one, this is quite close to home. This may have happened to FSB, or certainly somebody who's been represented by FSB, where we've said, listen, you're infringing here. And they come back and they go, prove it. Prove that you've got copyright over what we've just used. Prove it. What's our answer to that? Well,
as long as you've registered your trademark, you can print that off from the IPO's website. And
what about copyright? What if it was copy from a, can you point to the date, or is it something that you've, tell us?
Well, if you're referring to sort of an online website that had been taken, then yes, you can do it. But you would need to be able to show that that was yours prior to it being used by the third party. So record keeping is useful and is sensible. If you're able to perhaps take a screenshot of your website with the date and time on the clock, and know it's not infallible because you can change it. But if you perhaps could do that and then email that to yourself in the same way that Miles was speaking about, songwriters used to send posted letters to themselves. That is just a little bit more that shows that you've got that. There is, of course, the software that can do that for you as well, to keep the time and date stamped. Things like doing a PDF of a document is always very good because that time and date stamps it when it was produced, and things like that.
Brilliant. Neil, again, we're all busy on this one. What's coming for you on this?
Well, I wanted to pick up on what Miles was saying, because where you've got someone who has a registered class of trademark for particular goods, and someone else wants to register the same mark for those goods, then what Miles will tell you about in more detail, if need be, is that there is a process. So if you notice that someone has applied to register the same name for different products in the same class, you can raise what the IPO called an opposition within that application. And there is an internal IPO process, which is not as expensive as court proceedings, but can in some cases carry some sort of costs, obligations, where an adjudicator within the IPO will decide whether or not the two different usages are sufficiently confusing not to allow the second application. That's the first thing I just wanted to add. Second thing, in terms of sound, we're getting a bit away from brand stuff here. But the sound recording copyright position is slightly different. If you're looking at the venue position, the venue will normally have a license from the Performing Rights Society and Phonographic Performance Limited, which will cover both the song copyright and sound recording copyrights. And there's a process normally in venues where they fill out set lists and they register those with the collecting society, and they reflect the royalties in the statements to the copyright owners. The performers who perform those songs also have rights, and they register with PPL, and they can get a share of the rights through the PPL system. It's something like 50%. So there are a number of different layers there, but it's not really a brand issue for today.
Good to know. Miles, I mentioned right at the beginning, if you don't have the right protection, or even if you do, the chances are, if this does happen to you, if there's some sort of infringement, or perhaps you're accused or whatever, financially and reputationally, it can have a massive impact on you and your business, plus all of the stress, which is the last thing we want, particularly in the current climate.
Absolutely. I mean, I think, and this is why, a lot of work has gone on in the UK in the last sort of 10, 15 years, the creation of PIPCU to help people at the more serious end. A lot of work by judges to simplify the legal process, to get that balance right, that it gives relatively straightforward access to justice for smaller businesses. Is it perfect? Probably not. There's more we're trying to do. There's a small claims, there's a more advanced court, there's talk of an online court, all sorts of progress being made on that. So that, but yeah, I absolutely accept this is a significant decision. If you take enforcement action against someone, both in time and the sort of stress, as well as the money that you'll spend, whether you do it yourself or whether you get professional advice. And I strongly recommend that people do get advice if they get into trademark disputes. As Neil said, you've got to be very careful about unjustified threats, firing off letters to people comes with some risk. But yeah, there's no question. And I think this is why getting advice, getting information and understanding what you're taking on is so important. It's like a physical asset. If you own a big building as part of your business, you insure it, you maintain it, you get the gutterings cleared, you make sure that it's protected. Your IP needs to be managed in the same way. You can't just register it, sit back and forget about it. It does require a bit of management, due diligence. Where is it going? How can it be better protected? Keeping an eye on the international scene. Someone's mentioned in the questions about business in the US that have got a very similar trademark to them now, and they've got a .com domain, and the business in the UK has got the .uk domain. Now, obviously, they may well be operating completely independently, certainly the question suggests that they are. So, in theory, there's never any risk there. You're operating completely independently. Your customers are UK based. They understand when they're buying your product, your service from you. You can't go around buying up registered marks all around the world and domains. I mean, frankly, you'd spend your life managing your IP. And this is why I mentioned people like Coca-Cola have massive departments doing this. I think you've got to take all reasonable steps. You own the domain in the UK. You own the registered trademark in the UK. You use your TM in a circle or your R in a circle. Obviously, you've got to be registered to use the R. Take those sensible steps. Be aware of what else is out there. Obviously, if you start seeing signs of customers being confused, if another business is getting a bit too close, that's when you might want to think to start taking action. But I think if they're in a different field and in a different country, largely you're in a good position. You've registered a mark with us, and you've got the domain registered as well.
We're rapidly coming towards the end of the hour that we've allocated. We could talk for many more hours, I'm sure, and we will send out links to resources, etc. Neil, FSB is working in partnership with the IPO and the police and PIPCU and other bodies, aren't they, to protect small businesses?
Yes, that's absolutely right. I mean, I talked to Miles and his colleagues in the IPO about various issues, and we're particularly engaged with dispute resolution at the smaller end of the scale and IP-related, brand-related issues that arise from online platform sales, and trying to find some sort of fast and cost-effective way of dealing with those. The FSB has its legal protection helpline, which members can utilize. It has materials on its website. We liaise with people like the IP Federation. I go to the IPEC user group meetings where there are representatives from photography societies, the IPO, the judges, the literary people, a whole host of IP concerned representative groups. And so we're pretty active in that space. And we also, of course, talk to government about what they should be trying to do and think about potential digital services legislation that might tighten up some of the rather flexible rules that exist at the moment. But can I just, Dave, while I'm on, brief example just to illustrate what I said at the beginning. There was a case involving China Tang, where a Dorchester restaurant with that name successfully sued a takeaway in Barrow and Furness that used the same name that had been operating for 10 years and managed to restrict them on the basis that there was confusion between the two. Some people might find it surprising, but it underlines that you need to do your research before you start.
You're on mute, Dave.
That's a schoolboy error. After 2 years of lockdown, you'd think I'd know to unmute myself. That's what happens when the window cleaner turns up unexpectedly. But there you go. You see, we're still in the real world. Anyway, what I was going to say, and thank you for the heads up that I was on mute. How silly. Is to whiz round you guys now in the final minute or two that we've got left with if you could just give us one piece of advice, one top tip, what would it be? Let's start with you, Miles.
I think it's something I've already alluded to because we've gone into so much detail. You have to take responsibility for managing rights, registered or otherwise, copyright, whether you've got designs, trademarks, manage them, think about them as an asset, a piece of property. They can be incredibly valuable to a business, but they do need some care, some nurture, and some looking after. Do that well, and they'll be fantastic for your business.
Brilliant. And Ruth, just looking at somebody who's been through the process, what would your top tip be?
Definitely seek advice about what IP can be protected in your business. As Neil's mentioned already, is if you're an FSB member, you can call the FSB Legal Hub as a starting point, or if you're any small business owner, you can go along to the Business and IP Centre at your local libraries. So we'll share links with those after. They provide sort of training and resources and all sorts of things to help you get a better understanding.
Peter, we shouldn't be, I mean, there's a danger, isn't there, sometimes that we over worry and get overstressed, but what would your top tip be?
Do your research, get your intellectual property registered as it should do, and then be reasonable with people that perhaps are trying to infringe that property. If you need to come to the intellectual property crime unit in the City of London Police and you have already taken steps to deal with that issue, that will work much more favourably for you. If you come to us having not made any attempts to try and deal with any infringement, by way of cease and desist, for example, that is often harder to take forward at a criminal level. So as long as you've tried to protect your own rights and it's not been successful, then come to us and we'll be able to take that forward for you.
Yeah, and we know that unit will very quickly say whether there's a case or not to be had. Neil, finally then to you, your top tip.
It's repeating the same thing again. Research and preparation before you start. As Ruth says, monitoring after you've commenced your business. Bear in mind that there are brand protection agencies worldwide who are monitoring the web and monitoring your usage. And if you get accused of infringing someone else's brand, then, as I've said, we have the FSB legal helpline for members. But this is an increasing issue that arises frequently now.
And on that note, thank you. A good plug there as well for FSB. FSB does have resources if you're a member. Certainly there are resources online on FSB's website, regardless of whether you're a member. Do take a look at those. What we'll do next is we'll send a link to this recording, just in case you want to re-listen or share it with colleagues, go over something that was said if you didn't quite follow it. We'll also include some useful links to websites and resources. And that will include the Amazon Small Business Accelerator. We're extremely grateful to Amazon for their support and their partnership for today's webinar. They've been helping businesses since 2020, over 600,000 small businesses. And you can go to the Small Business Accelerator hub and pick up free resources, advice and tips from there as well. And it's good to see that we're all working in partnership. So keep an eye out for that email. If you've been watching today or if you were registered, you'll pick up those resources. This is just the start of the conversation. There's obviously a lot that we could have covered. And if you've got questions, of course, we'll try and answer those in that email if we haven't already covered them off today. So there you go. That's the hour up. I want to thank you on behalf of FSB, Amazon and the Small Business Accelerator. Thank you to Neil, Peter, Ruth and Miles for joining me today. But for now, I've been Dave Sharp, not on mute, but loud and clear, saying goodbye and see you next time on the 27th for our next webinar all about finance and fundraising. See you then. 24th, not the 27th. Beg your pardon.